As we continue with our physician series, today we're going to talk about physician contracts and compensation 101, a practical approach to physician contracts and compensation structures. My name is Angela Lopez. I am an attorney and the managing partner of ALMA Law. We have been in business and I have been practicing immigration law for over 22 years and focus or specifically to physicians. With me today is the very distinguished Mr. Kyle Clausen. Kyle is Resolve's CEO. Resolve provides contracts, negotiation services, and compensation data to thousands of physicians across the country. Kyle is passionate about leveling the playing field for physicians as they navigate their careers. He's a member benefit of most national physician societies. Kyle is married to a physician, has 3 beautiful children, and a dog. With you, here is Kyle.
Thank you, Angela. I appreciate that introduction. I'm happy to chat with you today, and hopefully we can get through some good topics here on physician contracts. And let's dive right into it. We're going to spend about 20 minutes here, and this is just you and I again, so we can skip that slide. But what I really want to talk about first is a little bit of almost pre-contract stage and making sure we understand what the objectives are for clients of yours and clients of ours as they're looking at this and when they should be engaging and starting to think about this topic. The first thing that I would encourage all of them to do is just identify their priorities, right? So before you even get into looking at a letter of intent or a full employment offer, you need to know where you're looking, when you're looking, if you're going to prioritize compensation or scope of practice or time, right? If it's going to be an academic center or not, those things are really helpful to do very early. And this with the immigration process, if there's immigration issues, you need to do that even earlier than normal, right? We always encourage people about 12 to 18 months, prior to them leaving training, if they're in training or transitioning from one job to the next is the right time to start to think about that and to do that. But once you've got hopefully that part figured out, our goal is to make sure that you understand contract risk, that you're understanding what's normal in the market, what data looks like, where you can go to find that data, and then also how to negotiate and making sure you're doing that in good faith. And so that's what I want to talk about today. I'm happy to take questions from anybody that's on, and or Angela, you have questions, too through this, and we'll answer those either as we go along or at the end. It's up to you guys. So let's talk about contract risk first. When I think contract risk, I like to try to simplify things as much as I can and think about it in 3 categories. So the first category of risk, and this is where I actually think a lot of people skip this part, right, or forget about this part, is what are my responsibilities underneath this contract? What location of practice am I going to be at? What's my schedule going to look like? How much call am I going to take? And so in column 1 over here, those are the first 3 things for a reason. Usually when clients come to us and they're unhappy down the road, if they're moving from one job to the next, it's almost always because something in that category fell through, right? They were taking more call than they thought, or they're working at a satellite location when they didn't want to. And so taking care of that language first is really important. Almost every contract is going to start out with really broad language on that topic. It's not going to define most likely how much call you're taking or where you're going to work. And so that's step number 1. Step number 2 in that same bucket would be if you have interest in outside activities, if you have intellectual property that you need to protect, those things are becoming more and more important, right? Side gigs for physicians, are popular. We do realize there's some restrictions on that, especially if you're on a J1, right, of what you can do from an outside activity standpoint. But a lot of these contracts are going to be in place beyond just that 3-year period. And so being careful and understanding, that component is important. And then finally, if you have any concerns on supervising APPs, and what I mean by that is, nurse practitioners, physician assistants, CRNAs, 1, you need to be careful on if you're responsible for doing that, but 2, if you are doing that, are you being paid for it and at the right level? Okay. And if you need certain time protections for things like administration or research or teaching, you'd want to carve that out as well in this scheduling and duties section. Okay. So that's category 1 for risk spotting. Your second category is being paid fairly, right? And we're going to spend some time on that. I'm going to show you how we think about evaluating compensation and some tools that you can use to find those numbers. But almost every contract is going to have some type of base or guaranteed salary, as well as a production component with it. Okay. And so you need to understand work RVUs and collection models, gross charges models, ASA units if you're in anesthesia. Some practices are looking at encounters now. And so all of these things matter, right? And understanding what percentiles you're at and trying to decide if the compensation is fair. So we're going to walk through an example of that here on the next slide. But other things that you may see, depending on location, signing bonuses and relocation allowances are both very, very common. Some of these other things are not. So student loan forgiveness, stipends while you finish training, those things may be in higher demand areas, right? Or a vacancy that has been open for quite a while. If you're not seeing those in your contract, I think it'd be a good thing to think about and evaluate the market and decide if that should be something you're pushing for. Those buckets can really vary as well. So when we start talking about data and medians and different percentiles, signing bonuses are one of the things that can really fluctuate, not only by specialty, but by, location as well. Okay. And then other pieces in that same category of compensation, obviously all your benefits are important to you, the CME allowances, the vacation time, other benefits like 401ks, health insurance, disability insurance, life insurance. Some of those things are going to be non-negotiable. Okay. And so I think that's important from a good faith negotiation standpoint to understand that if it's a 401k, if it's a group benefit, that they have a contract locked in for all employees, you want to spend your time on things that are actually changeable, and those maybe not. So, we can talk about that a little bit more later if people have questions on it, but you want to focus on things that matter. Okay. And then the final category here, when you're talking about risk spotting, anything that touches on termination. And, Angela, you know this too, but sometimes you want to plan getting out of the contract at the same time as you're getting into it. And that's hard to think about because you're excited, you want to be there. But most physicians now are employed. Most physicians are going to have 2 or 3 or 4 employers throughout their career. And so it's really, really important to know how you get out of the contract. Is there termination without cause available? What are the for cause issues? And then once I know how the contract can end, what type of financial impact is that going to have on me? And financial impact can come in a few different ways. So the first one would be your malpractice insurance and your tail coverage. You need to understand what tail coverage is. If you don't know what that is, it's basically a policy that protects you after you leave an employer, just in case a patient sues you from your time there. Okay. And so if a claim comes in when you're with employer B, right, your second employer, if you're on a claims made policy, there's no coverage, right? And so you've got to have tail in place to help with that. Tail can be pretty expensive. We'll talk about that a little bit later as well as kind of the range of what that can look like, but certainly a value point for you in a negotiation. Okay. Other things that have financial impact, obviously, if you took a signing bonus, if you took a student loan reimbursement or a stipend, there's likely going to be repayment obligations on that. And so the larger the amounts get, the longer commitment period they usually want, and the longer that kind of amortization schedule will look like. So understanding if you have to repay all of that or just a portion of that is really language that you want to identify the risk on and be careful on. And then other things like non-competes, may or may not apply depending on your immigration, situation. But certainly, long-term for your career, you need to understand what those are, why they're important, and we're going to talk about the value of that here as well in a little bit. And then the last one that I want to hit on this list, all of them are important, but the one relatively new piece that we're seeing is that post-COVID, a lot of force majeure clauses are coming into contracts. We didn't see that much, 5 years ago. We're seeing it more frequently now. Those clauses basically say that if there's a pandemic, which is considered an act of God, that the contract may be voidable, right? Or parties aren't held to their obligations underneath the contract. And so during the pandemic, we saw a lot of employers furlough. We saw compensation reductions. We saw scope of practice, get moved around. And so we just want to be very careful on that. If there's notice, if there's not notice, and what that looks like. So if you see that language and you don't know what it's for, that's the situation that it's generally trying to address. Okay. So let's talk about compensation for a second here. And I want to have you think about how you we'll evaluate if you're being paid fairly, and it's not just about your base comp. So if we're going to work down column 1 here, we're going to imagine that you're on a work RVU model, and in this situation, your contract has an offer of 200,000. You check the data sources, 200,000 happens to be the median, and so you're fairly happy with that. But when you look at the production side, if your contract is saying that you bonus after 3,000 work RVUs, and the median is 2,500, you should immediately be raising a little bit of a question mark in your mind as far as why there's a distinction between where your base is set and where your production threshold is set. Because if every work RVU is worth $40, what it looks like, or what it should look like to you, is that you're being asked to produce an extra 500 work RVUs as opposed to your peers, and you're not being compensated for that. And so 500 times 40, right? That's about a $20,000 amount every year that you're short. And so there may be justifications for it. There may be reasons for it, but I think you need to be asking those questions and certainly trying to correct it by either increasing the base, decreasing the threshold, or adjusting the multiplier so you get, to a position of being whole, at some point in the future. And you can take that same methodology and apply it to a collection model or a billings model. The goal is to make sure that if you're producing at a certain level, you're also being compensated at that level. Okay. And you may hear things like, we can't pay past a certain percentile for Stark or, compliance purposes, but almost all of those rules are structured to where if you're producing above a certain level, they can continue to pay you for that. And so just, again, be very careful on your comp models and understand what it looks like, not only today when you're signing, but also what it may look like 2 or 3 years down the road, when your volumes are different than they are at the start. There are a few things that I think, when we talk signing bonuses, that Angela, I'd like you to just talk on for a second. If there are J1 physicians or H1B physicians, on how signing bonuses could cause, potential issues.
Thank you, Kyle. Yes, we get that question frequently because one of the key or one of the benefits that the physicians always want to negotiate what they are undergoing training is signing bonuses, something that helps them out through the few months they have training. There's a situation here with specifically with J1 physicians. H1B physicians, no problem. Signing bonuses is very specific. It is only for the intent of you agree to work with us, and here is a bonus, and it's specific to when you start working with us, right? So if you don't start, you will probably have to give the bonus back or whatever. But J1 physicians, they have a specific restriction, and it's from the ECFMG. As we have mentioned before, if you have attended our previous webinars, any physician who comes into the United States on a J1 visa is sponsored by the ECFMG. And because this sponsorship, they are subject to going back home, but also they are subject to all the regulations that the ECFMG has for J1 physicians. One of them is they prohibit, the ECFMG prohibit J1 physicians from receiving compensation from outside their program. Any type of compensation. So a sign-on bonus might be considered violation of the J1 status. It's a great area because some attorneys don't see this as a problem, and they believe, well, sign-on bonuses is very specific in terms of intention. It's not actual work now, but in the future. There's different ways that it can be structured, and Kyle has always made very good suggestions. One of the suggestions that we make when it comes to signing bonuses is to treat it as a commencement bonus instead of a sign-on bonus, which means here it is, we're going to anticipate some payments, but it's only because you have committed to commence working with us at a specific date. That way, we will avoid the whole issue of ECFMG prohibitions and 1099s at the end of the year, and you should be okay.
Very good.
Recommendation is, if you see a sign-on bonuses, yes, talk to Kyle, but also include your immigration attorney if you're a J1 physician.
Yeah, I think that's great advice. So okay, so let's talk about we talked about kind of the risk points on this, but also let's talk about where to find all this data, right? Where can I go to know if my contract is normal or if it's not normal? There's, again, 3 categories. So we talked about the kind of 3 categories of risk. We're going to talk about 3 areas of data for you to know if, one, you're being paid fairly, or the contract terms are normal, or just, what's out there in the market. So the first one that I want you to think about is what I'm going to call survey data. Most employers are going to reference some survey in their document for compliance purposes. It often looks like this paragraph, bottom left, that says, notwithstanding anything else in the contract, we can't ever pay past a certain percentile of, and in this example, it's an MGMA survey, okay? So if you see that, that should be, again, bells going off saying, okay, they think MGMA is a valid data source for fair market value because they're using it for compliance. And so if it's good for them, right, it should be good for you as well. So you want to have access to these surveys, MGMA, AMGA, Sullivan Cotter. There's a few others that are out there, AAMC. No data source is perfect. And so I want to start with that, including ours, which is the second category, right? But I think having access to as much data as you can is really helpful. Okay, so get access to some survey data. Second piece I would tell you is, if you don't have a lot of other offers, you at least need to have a snapshot of the market of what verified contracts from your peers are looking like. You can get access to that on our site. If you go to resolve.com, you can create a free account, and you can kind of cruise this up and down and at least see on a confidential, anonymous basis what some offers have been out there. It'll show you things like base salaries, signing bonuses, or commencement bonuses for this purpose. Relocation allowances. It also includes other contract details like what are non-competes looking like, what are conversion factors looking like. And so it's another really good tool for you. And it's also live. It'll give you notifications, right, as new data points come in, so you don't have to guess at when to come back and check it. And then the third category of data, and this is always your best data source, is to have those other offers in hand. So if you can go out and get 3 or 4 contracts side by side at the time you're looking in your specialty, hopefully in a geographic area that's close or similar, right, categories, that's really going to help you not only from a leverage standpoint, but also know for yourself personally what fair market value looks like for you. So access survey data, see what the market is doing for your peers, and also have offers yourself. If you can do those 3, I think you're going to be in a pretty good spot. And the reason I encourage you to have as much access as possible is because data, like I said before, can really vary, and it can really vary based on the filters that you pull. So when you talk about surveys and any data set, you can filter it by location, you can filter it by how long you've been in practice, by employer type. And so for a single specialty, right, we can pull different filters and get all 3 of these numbers on the screen as a median. So we can get a median of 123, we can get a median of 242, or a median of 316. Obviously, you want 316, right? And so how you pull the filters matter, making sure you're getting accurate numbers. Most of the time when we deal with employers, they know this, right? And they're going to try to pull the filters to get them to a number that's generally as low as possible, right? They want to reduce their labor costs if they can, and you're wanting to do the opposite. And so making sure you know what you're looking at, not just that it's MGMA data, for example, it's what filters within that, right, are we using to get to the right values. And that's same for work RVU thresholds. It's the same for conversion factors or collection percentages, right? It applies to more than just your base comp. So be very, very careful on that and make sure you're understanding what those data sources look like. Okay. All right. Final thing I want to talk on, and then we'll take some questions at the end, is just how do I go about negotiating if I go through and spot all the risk, if I have access to all the data, and I just say, hey, this, there's some things that need to be adjusted. How should I go about doing that and effectuating that change? We think you should do everything in good faith. So if you're going to ask for something, there should be a data point to go along with it, or industry norms to substantiate why you're asking for it. It doesn't mean that you can't ask for unique things, right? Every situation is different and should be customized to your specific situation. But it also means that we don't probably go through and try to recreate their entire document for them, right? They have a template, right? They're wanting to stay usually within some railroad tracks, right, of what that looks like. So make sure you're doing it in good faith. Make sure you know what your BATNA is. So every negotiation class you ever listen to or talk to talks about your BATNA. You have to know what your options are, basically, if they come back and say no to everything, or if the deal falls apart. Do you have a plan B or a plan C? Do you have, justifications for why you're asking for it? If you don't know what that outcome looks like, it's hard to go in and, assert claims on things that you want to have changed. Okay. And then finally, you need to be prepared to answer or respond to the statement that this is our standard contract and we never change it. Because you're going to hear that from whether it's a sole practitioner or a group of 1,000, right, physicians that are employed. Everybody has their standard contract, and Angela, you can probably talk on this too, to some extent. We see changes in a lot of documents, whether it's for immigration purposes or compensation or just the situation needs to be adjusted because the client won't sign without it. And so I would encourage you to be ready to answer that question and to still go further in that discussion. This is an example of how one we know, right? Because we see thousands of these every year, so our sample size is bigger than any individuals it's going to be. But this is the type of response that you might see where this contract is good that we offered to your client. It's been vetted by everybody, right, over the past 15 years. We don't make changes, but that being said, we are going to adjust it, right? We are going to change the non-compete because it was important to this position. And so when you see things like that, I think you just need to know you may have to push hard enough to not always walk away, but really let them know that you're not signing unless certain things are changed. And I think you'll have good success and good results. So is it worth it? Should you go through maybe some of the stress of negotiating contracts? If you're focusing just on compensation, a 10% increase in your comp, over your career is worth about $2.5 million. So I would say it's absolutely worth your time and your effort to pay attention to fair market value, to pay attention to your contract and make sure you're getting the terms that you want. And also know that it's not just compensation that has value. So when we talk about other things, right, throughout your career that are going to have value, tail coverage and non-competes are both fairly high value numbers, depending on your specialty. So if we think non-competes first, the FTC is talking about potentially getting rid of non-competes, which would be great. But until they do, part of their analysis talks about compensation reductions and kind of the lack of competition that happens in certain markets. And they think that there's potentially a 37% reduction in physician compensation because of non-competes. So 37% is, it's about 9.3 million in career earnings. So really, really important to get rid of that if you can, because it opens you up for, leverage and negotiations later. And then also on tail coverage, tail can be anywhere from a very low price point, right, of $5,000 to potentially 150 or more, right? And so by specialty, that's what drives those distinctions mostly, and also your history, right? If you've had a lot of claims or if you haven't. But don't forget to negotiate on tail because it's oftentimes worth just as much as a signing bonus or something else. Okay. So with that, resolve.com, if you need to go get access to some of these free tools, if you need help on this, we're happy to do that.
So it's great, this information. Just a little note on the non-compete. Keep in mind that if you are a J1 physician and you're looking for a waiver, well, at least for the first 3 years of your contract, there's not going to be a non-compete clause because the federal agencies do not allow the non-compete clause. But after the third year, you bet those employers might be pushing for a non-compete or some sort of clause that will protect their interest. Kyle, I do have a couple of questions, or a few questions were asked during the week by some of my clients, and a couple of questions that I thought about as we were doing the presentation. So one of the first questions is, as a J1, as a resident, regardless, J1, not J1, H1B, as a resident or fellow completing training, what is the best approach to start negotiating a contract?
Yeah. So especially residents and fellows, they tend to have some reservations, I think is the way I would frame it, on how hard they want to push. It's the first time, right? They go through medical school, and then they match, and it's the first time that they have some control over their career. And so my recommendation would be feel empowered, first of all, right? That you're in high demand. There's a physician shortage. There has been for a long time. And so supply and demand is in your favor. Make sure you're educating yourself on this. I think the hesitancy a lot of times comes in from not knowing what's normal, right? They don't know what tail is supposed to look like. They don't know what conversion factors look like. And so hopefully if you listen to this, you're going to educate yourself and have access to some of that stuff. And then I think it's about tone, right? And it's about trying to create what hopefully is a win-win relationship with you and the employer. I mean, it's not a you're going to go in and try to ask for things just to win a negotiation. The idea behind solving some of these issues is because you hopefully want to be there long term, or at least you want to be there if it's fulfilling a waiver, short term and to be happy, right, with a chance to stay long term. And so if you get into a bad contract, the likelihood of you staying is not great, in my opinion. So hopefully the good employers recognize that, and I think are willing to make some of these adjustments because of that. And they also tend to be closer to fair market value as a starting point, rather than lowballing you out the gate. So my suggestion is try to find, again, a few offers so you have hopefully at least one or two good employers in that bucket. Educate yourself, and you should be in a pretty good spot.
Yeah, I have another question here, and it's kind of a follow-up question. For those physicians who have non-immigrant visas, J1s, H1Bs, frequently they want to include some sort of language in the agreements for employers to pay or help with their immigration green card process. So they want to know, okay, how much is too much or how little is too little, But one of the things that have come up in terms of them requesting, can you pay for my fee, pay for my immigration fees instead of, I don't know, some other benefit. Some of the things that physicians are concerned are the penalty clauses or some sort of clause that says, yes, we'll pay for your immigration fees. And keep in mind, there are certain fees that cannot be repaid, but there are many that can. So how do you deal with, I don't want to pay a bunch of money at the end if I breach or end the contract early. So what can they do?
Yeah, so this is, it definitely applies for immigration fees. It also applies on any commencement bonus or relocation allowance or anything else. You want to be very careful on when you have to repay it, right? Because there are situations where if your employer is in breach of contract, or they terminate you without cause, or if private equity comes in and buys them out, right? There's a merger, something like that happens. You want to have exceptions and exclusions to that. So it's really only going to be repaid if it's what I'm going to call a without cause termination, or kind of a no fault by the employer, where you're changing your mind, you're walking away, right? Where it would make sense. It's kind of equitable, that would have to get repaid in that setting. Outside of that, I think that they should be paying for that in all those termination settings. And then you also want to accelerate the amortization of that as much as you can. So, if you're under a 3-year contract, hopefully having the immigration costs waived after 12 to 24 months would be ideal. You certainly don't want to push it beyond the 3 years if you're there on a waiver. So that's another thing to just be, again, cognizant of and aware of, because if you have a large signing bonus, for example, that is amortized over 5 years and your commitment's only 3 for immigration purposes, now you're in this weird limbo where you might have a repayment obligation if you want to move on.
Wow, thank you, Kyle. 2 more questions, and I think I'm going to let you go.
Sure.
Consideration of your time, but some physicians were asking about letters of intent. They have heard, and some of them have received letters of intent instead of contracts. Is that a letter of intent? What should they say or have, and will that replace the contract?
Yeah. So letters of intent or term sheets or memorandums of understanding, they call them different things. Usually that's a starting point for coming to terms on compensation, right? Kind of the 5 or 6 high points, right, that they want to, have you commit to before they go and draft the full document. Now, that being said, some organizations, especially like academic organizations, your contract is going to look very much like a letter. And it's only going to be probably 3 or 4 or 5 pages, kind of at most. And so we often have clients confused that this is just a letter of intent because it looks like the other letters of intent that I've got, they sign off on it. And then what they fail to realize is that was it, right? that was their chance to negotiate. Now they're locked in. And so I think you need to be careful. Most letters of intent are not binding, but it's certainly not 100%, right? And so if you're going to have that, my suggestion is you need to negotiate what's on there at that point in time, because it's really unlikely that if you sign off on a number that they're going to come back and renegotiate that with you later. Legally, you may not be bound to it, but just human interaction says, we thought we agreed to this and now I'm upset about it. So my suggestion is start the negotiation at that point.
Great, thank you. And this is a question that I thought about as you were speaking. Many physicians and many people in general we sign contracts without even thinking about what we're signing, and many times not even knowing what is in the contract until after we signed. So what would be maybe 2-3 tips or red flags that you can tell people if you see this type of language on the contract, you definitely need to talk to me or an attorney to review your contract before you signed?
Yeah. The things that I don't like revolve around how a contract can be amended. So if you're reading through a contract and it says, we're going to pay you whatever, $300,000, right? However, at the end of that paragraph, it says this is subject to our compensation policies and procedures, which could be amended from time to time, right? So if you see enough language like that, and specifically in comp, I mean, that to me is a little bit of a red flag of you're not really agreeing to anything, because they could change it before you even start if their comp policy changes. And so, that would be one for sure. If you have a non-compete, I mean, for immigration purposes, it's supposed to be gone anyway. But if there's a non-compete in place that's really broad, right, or that they're tying it to multiple locations and it's really going to wipe you out of an entire market, I mean, I think there's this thought process in the physician community that they can't enforce those. Most states you can enforce them, and it's a question of if it's reasonable. And to get that determination is going to be expensive, right? You're not going to have to go to a judge to find that out. So I think those are the two big ones. Is if the contract can be amended in more than one spot, that's a red flag, and then the non-compete being too large is also, a really big red flag for me.
Well, thank you so much, Kyle. I don't see we have any questions on the chat. Appreciate your time as always. Thank you for joining us. You have our information. We'll be emailing the presentation, and hopefully we'll have Kyle again sometime in the future for more insight information. Thank you, Kyle.
Thank you. Bye-bye.
Thank you.